Good morning to all. Now, last session we have discussed two important sections, section 1 and 2. Now we are going to see that section 3 in the course Indian Maritime Law and Ship Arrest. Now we are going to see statutory regulations of maritime law in India. Statutory regulations. There are various regulations. It is mandatory to focus on maritime law in India. So what are various legislations are mandatory? Say for example, in our country, there are most important laws with regard to maritime law. It is very much important in order to render especially sea transportation, for which Merchant Shipping Act. This act is foremost act 1958 enacted. Carriage of Goods by Sea Act 1925, whereas taking the goods from one place to another place with the mode of a vessel, sea transportation, for which this act is very much important. Bill of Lading Act documentation 1856. Major Port Trust Act 1963. This act which deals with the port regulations. And Multimodal Transportation of Goods Act 1993. This act which is totally different from the previous acts. So if say for example, if you decided to take the goods from one place to another place, not only sea transportation, rail transportation, road transportation, air transportation, also last includes sea transportation. Likewise, there are various transportations are includes. So that's why for the same consignment, this act is very much important. Multimodal Transportation of Goods Act 1993. The next one is Indian Registration of Ship Act 1841. How to register the ship. So it is not very easy just like that where we are registering the property, for which they have enacted an act. In this act, we can know about how to register the vessels. So what is the procedures, formalities, documents and other things which are required to register the vessel by the ship owner. General statutes. There is other common acts. Indian Port Act 1908, Control of Shipping Act 1947, Maritime Insurance Act. If the vessel was met with an accident, then this act may be enacted. 1963, Contract Act 1872. This one is another important thing, whereas either a ship owner, a charterer, a ship broker, or port agent, or any other party, one who decided to have a contract, agreement. The agreement means dealing between two parties, for which contract is required. Contract means offer, acceptance, agreement, and it should be enforceable by law. So any agreement between the two parties should be enforceable by law, not against the law. That which comes under Contract Act 1872. Customs Act, another important act. Customs Act 1962. Based on the jurisdiction, Maritime Zones Act 1976. Coast Guard Act 1978. Arbitration Conciliation Act 1996. This act also, the party only entered with an agreement. This point, Arbitration Conciliation Act is plays another important point, whereas how they are going to resolve the disputes between the parties, either through the court or through the arbitrator. Arbitrator means a private party one involving here resolve the disputes between the parties. How the dispute is going to resolve with the arbitrator or with the help of conciliation, for which this act has been enacted in the year 1996. The last one is Territorial Water Jurisdiction Act 1872. Likewise, there are various general statutes which forms in the maritime law. Next one is Indian statutes governing maritime law in India. As we discussed already, the first one is Merchant Shipping Act. This Merchant Shipping Act establishing a National Shipping Board procedure for administration on Indian shipping by establishment Office of Directorate General of Shipping, in short form DGS. Procedure for registration of ships, ownership of Indian vessels, certification process, and classification and employment of seafarers. All these comes under Merchant Shipping Act. The Maritime Trade practices the control over foreign ships and vessels coming to India for various economic activities, for which specific types, which is very much important with regard to investigation, the inquiries, as well as the penalties also, which comes under this act. Merchant Shipping Act, safety measures are there. So what are the various safety measures which comes under this act? Fixed liability for pollution at sea and limitation of liability. The Limitation of Liability Act is the 1963, but the limitation of liabilities, it totally differ on various bases. For example, from 6 months or the 3 months or the 3 years, 6 years, likewise a limitation of liability which prevails. That which we are going to see in detail about what is the meaning of Limitation of Liability Act in 1963, measures against maritime pollution, provisions for wreck and salvage, and provision for coastal trade. All these are very much important safety measures which has been enacted in the Merchant Shipping Act. And the next one is for this, there is an important case law, British India Stream Navigation versus Shanmugavilas Cashew Industries. It means this case which focus on what, which describes on what, means no foreign ships or owners are deprived of their rights by our statutory enactment unless that foreign ships entering our Indian port territorial water within the territorial jurisdiction. So Indian statutes are ineffective against the foreign property and foreigners outside the jurisdiction. So that last, this case which clearly states the one more major important point, no foreign ships or owners are deprived of their rights by our statutory enactment unless for those foreign ships while entering an Indian port or territorial waters, they should see that one within the territorial jurisdiction. There are various laws which governs the carriage of goods by sea, POGSA, in the year 1925. First we have discussed about Merchant Shipping Act. Now we are discussing about Carriage of Goods by Sea Act. So what are the various laws? See, if you are going to take the goods from one place to another place, carriage of goods by sea with the mode of sea transportation. Second one, the documentation is very much important. Which document is very much important? The people, those who are dealing with this vessel transportation means exclusively, let everyone knows very well about Indian Bill of Lading Act 1856. The document means Bill of Lading. That which shows the evidence of the complete particulars which is required to be presented in the document. Third one, as we discussed, POGSA. Last one, Merchant Shipping Act. See, again and again when we are discussing about this, the various statutes, the first one is Merchant Shipping Act 1958, another one is POGSA Act 1925, and third one is Indian Bill of Lading Act 1856. What is the meaning of POGSA? 1925, the agreement is concluded between two parties. One is carrier. Carrier means the person who is taking the goods from one place to another place, and a shipper for carriage of goods by sea. So here, while the party who decided to take the goods, carriage of goods by sea, one most important document, Bill of Lading. So since we are involving this Bill of Lading, another important act may come into force, Indian Bill of Lading Act 1856. To any other port, either inside India or outside India, again there is a most important convention, Brazil Convention, which covers from which time the goods are loaded and which time the goods are going to what? Unloaded, which may be taken into account. It is called as carriage of goods by sea, the agreement which is very much essential between the parties. The carrier is responsible for the ship seaworthy, properly man, equipment, supply the ship properly, carefully they should load and handle and store, carry, care for discharge the goods. Enforcement, right of cargo interest for recovery of their claim. Yes, the party may have right to recovery of their claim. Sometimes it arrest of foreign vessels formed in Indian water governed by Admiralty Court Act. The judgment of Supreme Court, one most important famous case, that which is very much important, the people, those who are dealing with this maritime law, M.V. Elizabeth versus Arwen Investment. This case at last deals with what? Arrest a vessel, any damage by a ship. So the last point, law of limitation of liability. Protection to our owner. What is meant by limitation of liability? Means it gives a protection to an owner against the large claim for exceeding the value of ship and cargo. So commonly accident causing damage to cargo, not only cargo, property to another vessel, or loss of life or personal injury. The Convention on Limitation Liability for Maritime Claim, which has been enacted for all these essentials in the year 1976, for which there is a Maritime Claim Act 1976. Multimodal Transportation Act 1993. Two or more than two modes of transportation. As I told already, there is more than one mode of transportation. Single transport document covers what? All mode of transportation: rail transportation, air transportation, sea transportation, road transportation. So for which multimodal transportation operator remains liable and responsible to cargo owner. Operator is liable. Goods are damaged when they are in custody. Who will be liable? Operator is liable. Not liable unless the action against the multimodal transport operator is brought within 9 months of delivery of the goods. So this point only it is called as what? Within 9 months delivery of the goods from the date, they should take the action against the party. If they fail to take the action against the party, then they should submit the sufficient cause, the reason why they have not yet submitted or brought the action against the respective party within 9 months. So I have been delivered, the date, the party intended to deliver the goods has right to treat the goods as lost. So likewise, it has been delivered or the date or on and from which party intended to deliver the goods has right to what? Treat the goods as lost. So which one is the most important point here? The two mode of transportations are involved with the single document, more than one. Okay, if the goods are damaged in the custody, operator is liable, but not liable means you should take the actions against the respective proper person within 9 months. Otherwise, the goods treat what? The goods has right to treat the goods as lost. The person may have right to treat like that. Admiralty Jurisdiction Settlement of Maritime Claims Act 2017. Laws related to Admiralty Jurisdiction. High Court of Hyderabad, Gujarat, Kerala, Orissa and Karnataka. Act also allows the central government to extend the jurisdiction over any other high court. Proceeding on maritime claim, lien means LIEN, retaining the vessel, detention, sale of vessel and other connected matters. For all these matters, what? Jurisdiction plays a major role. So every vessel in India, territorial waters, irrespective of the place of residence or domicile owner of the where the owner is residing or the place of residence, it is not important. Apart from that, which one is very much important? Territorial water. The act not applies to non-commercial purpose, either the vessel owned, operated by government or foreign vessel. All these points that which comes under Admiralty Jurisdiction Settlement of Maritime Claims Act 2017. Jurisdiction of court in India. Yes, initially High Court of Bombay, Mumbai, Madras, Chennai and Calcutta, now Kolkata, okay, can make order with respect to the vessel within the water of Indian territory, domestic limit of the various territorial waters. Mumbai and Kolkata High Court and referred others, they can arrest the vessel irrespective of its location, provided vessel within the what? Territorial waters. So to arrest the vessel, they should see that the territorial jurisdiction plays a major role, that which comes under jurisdiction of court in India. Likewise, in this section 3, statutory regulations of maritime law in India, we have discussed about the Merchant Shipping Act 1958, Carriage of Goods by Sea Act 1925, Bill of Lading Act 1856 and Multimodal Transportation of Goods Act 1993. Not only these acts, again one more most important act also we have discussed, Territorial Water Jurisdiction Act 1878. Hope you all understood this section 3 on the most important course, Indian Maritime Law and Ship Arrest. Now proceeding with this conclusion of this chapter, now we are going to start a new section 4 which we are going to discuss in the next class. With this, I will conclude this session. Thank you all for attending this session.